Today we're going to be talking about Charlie Kirk, his passing, his legacy. Charlie Kirk was a very influential figure in my life. In the past few years that I started following him, his rhetoric, his insight, but most importantly, his courage and the way he stands, and he dedicated his life to doing this work of going from campus to campus, talking to students, talking to people, and sharing his beliefs. His positions, his points, his arguments, I disagree with. He firmly believed in his conviction, and he shows up and he faces the crowds, putting his life in danger for his values. He touches on everything in American politics and global politics as well. People don't really know how I admire that. And in the way I process cases, in the way we do a lot of these cases, I actually use a lot of the stuff that he says. And I want to share that. Probably nobody would have expected how what he did impacted this Chinese immigration lawyer here in California in helping clients get visas and get green cards. A lot of things he says, whether you agree or disagree, right? For example, I disagree with a lot of his conclusions, but his sentiment is real and his observation is valid. For example, he says, America is full. We're up to the brim. No more visas, please. No more people from certain countries, please. We are maxed out. He has a very strong sentiment about that. And, given from his perspective, going from college campus to college campus, stadiums are full, every city is full, housing prices are skyrocketing. Sure, it looks full. Every city is packed. New York City, it's twice as big as it was, 20 years ago. How can one small part of land contain that many people? Yes, in a lot of ways, it is pretty maxed out. But from a completely different perspective, me dealing with a lot of EB-5 investments, I hear a lot of congressmen say, America needs so much more people.
But I do want you to know that I hear from employers in my district every day about the need to fix our broken immigration system and allow more people to come here and work.
There's so much more investment that's needed. When you take a flight from LA to New York, when you fly over the lands, there's pockets of cities that are very populated, but a vast majority of the Great Plains is empty. More cities, more schools, more city halls, more libraries, more economic activity. There's still so much land and prosperity to be had. Is America really full? In the way when we do a lot of these cases, right, when we're doing an EB-5 investment, we make the argument, right? Congress enacted this law so that foreigners can invest, they can get a green card, and they can make America great. They can hire workers, but they want to hire in remote areas. And so America is full, but not this area that I'm investing in, right? This area, the unemployment rate is sky high. It's way higher than the national average. People don't have jobs in this location and they cannot move out. Without this investment, this city, this business will collapse. And so they're investing. So please, we've invested the $1 million. We've hired the 10 employees. Please allow us to get the green card, right? We fulfilled the promise that America wanted. That's one of his great points, that America is full. Another one that he mentions is that American politics, American immigration should prioritize American workers. When we apply for EB-2, EB-3 applications, for green card applications, we don't know who the officer is on the other side. We don't know who the adjudicating officer is, what their political beliefs are. And so they might completely feel like, wow, all these foreigners are getting green cards to be able to work in the US and take any jobs, because once they have a green card, they can pretty much take any job. Shouldn't America prioritize Americans, citizens first? So in our application, after the EB-2, EB-3 gets approved, in the adjustment of status application, we show the officers every single application. This is the timeline of this particular application. The client came when he was 16, 17 years old, graduated college, was on F1 OPT training, and then got an H-1B 3-4 years, and then file for the EB2, EB3 to wait for the green card. That took another 5 years. And then finally, after 10, 15 years of entering the country, finally being able to get a green card. The American immigration system has prioritized American workers, right? There's so many hurdles for a foreigner to have to jump through in order to get a work permit, to get a work visa, to get a green card, and then eventually to be a citizen. The existing system that we have, and this is a system that I'm battling day in and day out. So when Charlie Kirk says we need to prioritize American workers, I say the system is already doing that. To get a wage determination just to see how much your salary should be could take 6 to 7 months, at least, sometimes 9 months. To get a perm application through could take 2-3 years. To wait for a prior date could take 5 years before your first start date. How is that not prioritizing American workers? So when we apply for these, we show we have already prioritized American workers, and please, the company still very much needs this individual. So please grant the green card. That is the second major point that I really feel from a lot of his speeches and videos. And the third one, which is the one that really hits home for most people, is how mass immigration into this country is distorting the American culture, is distorting the American identity. A lot of the majority, the beliefs is being replaced. And that's why he says we need to stop the immigration. You know, if you just incorporate all these other countries of people, their beliefs and their values, too many of them come in all at once. It will change our civic life. It will change our education. It will change so many things about American culture. And he doesn't want that. His base doesn't want that. And a lot of people share that belief.
You cannot bring people into the country that don't share your values and still be a country. You could be something else, you just won't be a country.
And so when we submit cases for foreigners to be able to get visas and green cards to come into this country, it is imperative and it is so important for us to explain what are the values that they are bringing to help America. Because the thing about making America great, the thing about distorting American culture and diluting Western values is, what values are we talking about? That is the very central thing. And you don't want to cherry pick, because then that'll be distorted, right? So to be fair to Charlie Kirk, a lot of things that he values, that's great. Other civilizations value it equally, if not more. We could talk about education. We could talk about economic prosperity. We could talk about hard work. So the foreigners who are applying for visas are not all the same. We cannot compare somebody from Europe, from Asia, from a war-torn country to have the exact same values, and that they are all coming in and distorting American Western values. You could sometimes even make the argument that they might even have stronger Western values than the existing Americans who have it compared to the past. So that is something that I always try to make a point of. When they see consulate officers, when people see USCIS officers, look at their background, look at their values, and how do they fit in to the American way of life. I'm talking about like Western ideals, free speech. I'm talking about hard work. I'm talking about charity. I'm talking about humanitarian donations. I'm talking about entrepreneurism. I'm talking about, good family values. All of these things that make Western civilization great, things that make American great, things that Hamilton and the founding fathers valued and try to set up the country and democracy, all good. Don't assume other countries don't have that, and don't assume other countries might have it less than America. In fact, maybe what America needs are these other influences to make and to push America to be even better, right? So agree with the sentiment, agree with the point. You don't want too many people all coming in and dilute the system. Sure, but what values are we talking about? And how is it being diluted? Let's do it on a case-by-case basis. These are just 3 things in the past few years where Charlie Kirk's speeches just really, really impacted me. Because when I really listen to what he's saying, I see his observation. I see how the people that he's speaking to and his base are so moved by what they see America becoming and how hurt they are. And I understand their sentiment, and I understand their feeling, and I understand why he dedicated his life to go from campus to campus to speak to so many people. And I applaud that and I admire that. And I just wish he was still here so I could potentially see him, go to one of his rallies and speak with him and debate with him. I wish his family the best. I wish his base the best. And I wish that America can continue to move onward and forward so we can not see something like this happen again. Okay, I'll take some questions now.
Based on your experience, what do you predict with the EB3 visa bulletin? You think it'll move up, move back?
I think it will be different depending on which country you're from. And I also think it will likely, well, it's really hard. I actually don't do any sort of predictions, but EB3 is very interesting, mainly because EB2 has seen a crazy shift. And just in the past, experience, again, I don't like doing predictions, but anytime EB2 and EB3 gets kind of close together, being similar, then suddenly it will pull away again, right? So if you were to ask me, I think EB1 and EB2 will become up much faster. EB3 will still stay slow. And then when EB1 and EB2 gets really, really fast, then everybody's going to apply for it. And then it's going to slow down again in EB3 because everybody applied for EB1 and EB2. Then EB2 will get faster. But that's just historical trend.
Can service reinstatement, is it possible for medical reasons after a 12-month gap?
For what? For reinstatement?
Yeah, service reinstatement.
So if you're an international student, you're on F1, and somehow there's a 12-month gap between when you're supposed to be studying and you want to get reinstated, it is typically hard. The 539 form says 5 months. I've seen CBP officers really stickler about that 5-month rule. I've seen USCIS challenge with requests for evidence on that 5-month rule. However, with that being said, have there been cases? Have we seen cases? Have we done cases where it's been over 2 years, 3 years? Yes. These are all crazy hard cases. You have to have a really good explanation why you're supposed to be a student, but somehow there's like a 2-year lapse or 1-year lapse in your case, and you still file the reinstatement. How is it beyond your control? Now, again, if you're in a coma for a year and a half, beyond your control, sure. If you're not in a coma, what is the most coma-like thing that happened in your life that caused you to not be in school, right? So possible, hard.
I entered the U.S. via Mexico. I applied for asylum, but the judge denied my case. I applied for a BIA appeal, but can ICE detain me now?
We don't do asylum cases. This type of removal defense is not our specialty, not our wheelhouse. Based on my understanding, just browsing the internet, yes, ICE could detain you.
Is Overstays still being forgiven for marriage-based green cards?
Depending on who you marry to, U.S. citizen, yes, because of 245A. Non-U.S. citizen, for example, you're married to a green card holder, then you still need to apply for a waiver. So forgiven, but there's an actual application you need to file in order to get forgiven.
For your EWI clients that get detained, they can't bond out. Would you recommend voluntary departure?
It's a tough call. Most people would do it, right? Because who wants to be detained for months and months, years and years, and then without even a strong argument? But if you have a strong argument, and if you do leave, and you're never going to be able to come back, and you have no family overseas, and everybody is here, maybe that period of suffering is what's needed,
My green card is expired. Am I going to be deported?
No. Expired green card does not mean you lose your green card status, your lawful permanent resident status. Unlike a driver's license or any other thing, just because a card expires doesn't mean you suddenly lose all the privileges. It just means, it's invalid in a certain way, but you still have your status. So you are not deportable just because your green card is expired.
How many years does a 485 application typically take?
Hopefully not years, right? It really should be 6-9 months for a 485 application, because you've already fulfilled everything. You've already waited a priority date. So 45 is just one officer reviewing everything, and they should do it within 20 minutes. So you paid the thousands of dollars. They should just take 20 minutes and then maybe call you for an interview or not, and then your green card should be approved. So something like that shouldn't take years. And if it does take years, 2 years, 3 years, they have to have a really good reason, or else you can sue them under mandamus.
I'm a UK business owner. Is O1A to EB1C a viable route? I want to avoid L1 because of the 1 year only.
I'm assuming your 1 year only, you mean when you apply for the L1, you can only come in for a L1, but you can always file the extension and you get another 2 years. So that 1 year is not that big of a deal. The O1 you could do for 3 years, and then you can apply for the EB1C at the same time. And so that totally could work. You do O1A, come in, file the EB1C. Just so you know, right? Even if you don't do the O1, if you're still chilling in the UK, you can still do the EB1C. You don't have to do the O1 or the L1. The only reason why to do the L1 or the O1 is just to come in faster, right? So you could come in, file the EB1C, and then get a green card, or file EB1C, get a green card, and then come in. But your 1 year only, it's just talking about what happens after the 1 year ends. In O1, you can have 3 years, right?
Will those going through I-130 or 601 process right now likely to be detained if we get an interview or a biometric?
Biometric, so far from what I've seen and heard, no. I haven't seen news about ICE agents at biometric centers. At interviews, maybe, potentially, especially in going forward with USCIS having fraud officers who have ICE authority essentially to detain. So if you file I-130, typically there's no interview. In small cases, there are. So if you have an interview and it's I-130, you don't have a valid reason to be able to stay in the country, and if the officer doesn't like you, you don't have a valid reason to stay, you could get picked up.
Okay, my I-140 is approved. I have a 485 pending, done biometric, done medicals, but I recently filed an EB3. Am I going to have to do my biometric and medical appointments again?
Not necessary.
H-1B, I'm on H-1B, highly skilled with a degree. If I'm switching companies, how many days are allowed between jobs? Is it 60?
Between jobs. If you're talking about grace period, yes. But if you're talking about like you're working for job A and then job B files the I-129 H-1B application, the moment USCIS receives it, you can directly go over at work. So even before the case gets approved, right? So you're already on job A, because you're on H-1B status, somebody else files for you, you could switch over and work immediately. Now, that's not the safest thing. Maybe you want to wait until it gets approved and then you switch over, because we had a case like that where somebody switched over and they got denied, and then they go back to job A and beg them to, reinstate the payroll. It was a mess, but they did it and they were safe, but that's obviously a very awkward conversation.
If my 2-year green card for marriage expires, will I be deported, or do I lose my status?
No. We did a case, was crazy. Guy had like 5 marriages, 15 years had an expired conditional green card. He just kept on getting married to U.S. citizens. He never bothered to travel, never bothered to renew his green card. And then 15 years later, we filed the 751 and then got this case approved, right? Pretty crazy.
So to clarify on the L1, like 1 year question, U.S. business hasn't been set up yet, so it would have to be an L1 new office.
Right. So L1 new office, and then L1 extension, and then EB1C, right? So if you do O1, still same thing. O1 comes in, set up the office, and then do EB1C. You just kind of save the L1 extension after the 1 year, because your O1 allows for 3 years. So is it worth it to do that? maybe not. O1 application requires completely different set of stuff. L1 and EB1C is almost identical, just more in depth, right? So, yeah, I mean, most people would not do the O1 to L. I mean, maybe the only difference is if you need to bring people with you, right? O1 has that privilege of you could do O1 and then you can bring a whole bunch of secretaries and staff on O2, and then your spouse and children come on O3. I mean, up to you.
Can I start applying for citizenship after my criminal conviction was closed 4 years and 9 months ago?
Is your probation done, right? So case closed, you might, I mean, what does that mean? If it's dropped, if it's dismissed, great. You can do post-conviction relief and not, I mean, if it's completely dropped, you don't even have anything to worry about. You could just explain to the officer, I'm innocent. But if there was a conviction, then you should wait for the probation to be done before filing it and for 100 citizenship.
Any info or thoughts on co-sponsors for a stay-at-home mom?
I need a little bit more facts. I don't know. Do you mean you are a stay-at-home mom and you're petitioning somebody else from overseas to come, maybe like your parents, but you're a stay-at-home mom, so you don't have any assets or income, so you need a co-sponsor to help? Is that what you mean? Sure, yeah, get it. Like you need it in order to petition other people to come over, right?
Probability of U visa getting denied over DUI misdemeanor?
We don't do DUIs, U visas. But that doesn't mean it can't be done. There's plenty of U visa experts that can answer that question.
Are the background checks for DACA, green card, and citizenship the same?
The system USCIS uses to adjudicate these cases is the same. It's something similar to the LexisNexis system where they put your name in, put your date of birth in, put your address in, and boom, it pumps out arrest records, criminal records, convictions, liens, tax liens, alternative names. If you claim to be a U.S. citizen, all the different social security numbers that you may or may not have, boom, they see everything. But does that mean everything is the same in the way it's adjudicated? The answer is no. So they use the same system, they see the same thing, but to get DACA approved, much lower bar than compared to something like if you're deportable. That's a much higher bar, right? For the government to come and say, we're going to pick you up and deport you, they have to prove it. It's their burden of proof. So they have to be able to say, oh, wow, that felony was a conviction. We need to pick this person up and deport them. And then also, if you want to be a citizen, it's a different level of bar, right? So depending on who you are and what you're applying for, DACA, advanced parole, green card renewal, if you're a green card holder traveling and trying to come back, and whether the CBP officer will let you in, whether ICE will pick you up, whether you want to be a citizen and they determine you have good moral character. These are all separate grading systems, if you will, right? So with the same set of facts, same conviction, same traffic ticket, same DUI, are you for in one test, citizenship test, maybe it might be 85. You have to pass 85 in order to pass. But for something else, you have to be like 99 in order to pass. And some, if you have, 30 points, you can pass, right? It depends on what kind of application and benefit you're seeking.
Would you say the L1 to EB1C path is easier than the O1A to EB1C path?
For sure. Because L1, you've already proved at least half of your argument, right? Again, L1 and EB1C, it's almost the same set of facts. I was an executive overseas. I'm an executive. I'm going to be executive here. I own the company here. I own the company overseas. The funds are transferred. I'm performing this role. You're already arguing everything once, and it already got approved. So when you're doing the extension, you're just establishing, I said I was going to do this, and I really did do it. In fact, I did it better. And the EB1C is I did it way better. And so now I changed my mind. I want to stay, right? O1, completely different argument. So, but it's not undoable. It's just if you're trying to just to save that one extra filing, it might not be worth it.
Any update on advanced parole?
It's still super slow. Expedite requests are being denied everywhere, good reasons or bad reasons. So it's extremely tough. Here's an advice. Please double check your advanced parole. What I mean by that is a client of ours got advanced parole, but was only valid for 3 months. But they didn't know. They just thought it was the same as, everything else. So it's like 2 years or so. So they left the country. It expired. They're sort of stuck. Like that's something that we're actively trying to fix right now. And it's really hard. We're hitting wall after wall after wall. If advanced parole is expired overseas, you don't have a valid document to get into the country, and your green card application is considered abandoned. So it's a very tricky situation.
What's the most efficient path to a green card for a highly skilled H-1B worker? Say O1, EB2, NIW, self-petition.
Create an awesome dating profile.
Okay. Assuming that's not an option.
Because, you're highly skilled, you're high income, talented. I'm sure you'll get a lot of suitors, right? But assuming marriage green card is not an option, and assuming you don't have the funds to do an EB5 investment green card, then the fastest one is obviously EB1A, right?
If I get my final removal order dismissed, does USCIS treat it like it never happened?
No one will ever treat anything as if it never happened. Your A file is just always getting thicker and thicker and thicker. So it's always there. They always see it. And so whatever application you file for next, you have to deal with it.
I'm interested in L1 visa. How do I get started?
Check our YouTube channel. We've made 20, 30, 40 plus videos on L1s on different industries, different clients, how to go from L1 to EB1C process. Cases that got denied, we were able to reopen. So find out a little bit more about the entire process. And then if you like what we're saying, how we do things, our DNA and our style, feel free to book a consultation. We'd love to talk to you about it.
Shameless self-promotion. Okay. Further on the co-sponsor stay-at-home mom, they're applying for DACA. Husband is for marriage, green card. Husband is the sole provider.
And who are you guys petitioning?
Probably the DACA wife. Wife on DACA.
Okay. Well, if the husband makes enough money, you don't need a joint sponsor and it will go through fine, right? But if the husband doesn't make enough money, then you need to use the husband's assets. So stocks, crypto, housing, right? If he doesn't have enough assets or income, then you need a co-sponsor, right? And one co-sponsor isn't enough. You need a second co-sponsor.
Do you only see clients from a particular state?
We see clients in every country of the world. So not just in the US, but everywhere. With Zoom consultation these days, as long as the time difference matches, it's pretty simple.
Do you still have interviews for 751?
A lot of initial 751 cases, interviews get waived, but some waivers almost always gets interviews.
Can a revoked F1 visa due to a traffic infraction affect my adjustment of status?
I want to say affect in the sense that it is there on your record, the officer's going to ask. But if you're talking about legal analyzation, and if we're talking about going to the court and fighting it, a traffic infraction is not an inadmissible crime that prevents somebody from getting a green card. So that sentence is ultimately what you're arguing in court or in front of the USCIS officers who's adjudicating your case. To a consulate officer, you have a one social media post that they don't like, they could deny your visa, and there's consular non-reviewability, so they have full authority. So ironically, a social media post that gone awry, a like that didn't, that they don't like, a traffic infraction are grounds for consulate, even for a visa renewal, denial. However, in applying for a green card, those things are not an inadmissible, deportable offense in which to prevent you from getting a green card.
Yeah, it was a $25. They parked in a no stopping zone.
Exactly. So not something that will prevent you from getting a green card. So let's say you got married to a U.S. citizen and you're applying for adjustment of status. You're not going to be denied a green card because of that.
What's the price to start a marriage-based green card with you?
Our fees are online, right? Almost all our fees are online. Those are a general ballpark for a base fee. If your case is more complicated, obviously we charge more. The best thing to do is check out our fees, check out online, have a kind of budget in mind, but just start with the consultation. We tried our best to try to advise everyone so that they can do it themselves. Don't necessarily need to hire a law firm to do simple cases, but we're here to try to help as many people as we can.
Can an expedited removal order from CBP be vacated based on an error from the officer?
Yes. So I'm assuming what you mean is the notice of intent to appear was filled out incorrectly. And so can that be vacated? Yes. SCBP makes errors all the time on NTAs because that is not their wheelhouse. They're not supposed to be doing stuff like that.
How difficult is it to get an L1A on a small business or for a small business?
Don't assume small is therefore low chance. Really think about the merits of your company. So again, watch a lot of our videos. We go in depth, talk about how a few people, like, in fact, there was a company with like one employee, and it's like, oh shoot, and then L1 approved, and L1 extension approved, and EB1C approved, right? But every industry is different. So if you have like a small like a taco stand with 2 high schoolers, that's a hard argument to make that you're executive, right? But if you have 100 of these taco stands and you oversee all of them, you have regional managers, then it's doable, right? So really think about the merit of your case. And also, EB1C and L1 extension is forward-looking as well. So it's not just about existing in the past, it's also forward.
My mom is a resident since 2001. She applied on 98. She didn't petition me, but she mentioned me on the application. Can I fix this to get status?
That's complicated. I think we should, number one, do a FOIA to kind of pull everything, to kind of see it. We should probably do a consultation to kind of analyze it. You want to be careful of fraud, right? So if she didn't petition you, what was the reason why? Was it a typo? Was it a mistake? And if she didn't petition you and she has to petition you, your time might restart, so you might not qualify anymore. There are a lot of things that we have to like kind of analyze about that.
What should an immigrant in the process of an I-601A carry with them in case of being detained?
If you are married to a U.S. citizen, right? If you have a U.S. citizen that's sponsoring the I-130, so you have some sort of merit to be able to equitable tie in the U.S. That document, the I-130 approval, the U.S. citizen spouse document, and your job location, right? All of these are the most important things that ICE looks at to decide whether or not they're gonna let you have bond. That's, I think, what you're saying, right? What do you carry? So if ICE picks you up, what can you show them so you can potentially get bond?
I had a previous crime for fraud in my home country back in 2001, which was disclosed during AOS. I was granted a 10-year green card. No crime committed afterward. I need to renew my green card. Okay. Will I have an issue due to the past conviction that I already disclosed?
I don't think you will. In the green card renewal process, when you file the I-90, they mostly focus on the past 5 years. And so if it's that long ago, even before your green card application, I don't see it as a problem. So I wouldn't be concerned too much.
And if I apply for naturalization, will that become an issue there?
Completely depends on what that crime is. So again, different bar regarding what benefit you're seeking, right? So good moral character analysis for the citizenship is a very different application adjudication compared to can I get a green card? And getting a green card is different than can I get a visa, right? So each step of the way is getting harder. Now, a lot of immigration lawyers would have said in the past, citizenship, good moral character analysis is arguably the same as getting a green card. So if you got the green card, you'll get the citizenship, not a problem. But just with the newest release of the memo a few weeks ago, good moral character analysis by USCIS is undergoing a major overhaul. And so they're analyzing so many other things. And I anticipate USCIS becoming much stricter on citizenship applications, such that even if you got a green card, you might not be able to get citizenship just because of the same crime that was committed. I would not be surprised. With that being said, though, that doesn't mean you can't do other things to supplement your case so that you can get a green card afterwards, right? So, for example, maybe you committed a crime, but in the 10 years since, you've been going to charity, you've been donating, you've been fighting for a cause, you've been very involved with civic life, you pay all your taxes, you're an outstanding citizen, and so they grant you the citizenship.
Is SEVIS reinstatement possible due to medical reasons after a 12-month gap?
Yes. So we have a lot of videos on this on YouTube. Feel free to check it out. Some people have gaps for like 2 years, and we were able to get that reinstated, faults that are completely not their own. So depends on what the medical reason is and what you've been doing in this past year.
I just stopped by to tell you how much God loves you. Blessings.
Thank you.
Since I disclosed, okay, this is follow-up for the last question. I disclosed this conviction during AOS, and it was approved. So is renewing the green card low risk?
Renewing the green card is low risk.
And then has USCIS ever reopened old cases like mine during renewals, or is it usually a straightforward process?
I-90 renewal is a straightforward process. For a long time, it was even contractors who were doing it, so not official USCIS officers. Rarely do we see any pushbacks unless you have like a major felony. Then it gets bumped up to secondary review. So it is pretty straightforward. USCIS definitely reopens cases on their own volition, even if you don't file anything. So but again, only major issues that they're like spotting where they reopen.
My I-485 is pre-approved, waiting for the visa to be current, F1 family-based, have 5 years of travel documents, approved. Is it safe to travel internationally?
Your 45 is pending, so you have to travel on your advanced parole, right? So if you have an advanced parole and it's still valid, and make sure you come back before it gets invalid. And you just have to make sure you don't lose it, because when you travel with advanced parole, you lose that. It is so hard to come back. This L1 case was denied twice, and one of them was our own. The case was denied. The client came to us. We filed again. We got a request for evidence. We got a denial. Completely disheartened client. Feels like the world is collapsing. No matter what they do, they just can't get an approval. They even came to us, highly recommended, and we still got the case denied. We got a request for evidence that didn't say a single word. Everything was copy and pasted. Just not a single syllable was new. It was just boilerplate. And we rarely see those. We responded, and the case was denied. Boilerplate again. Disheartened, what should we do? We told them, let's file again, right? And if we file again and it gets denied again, then we appeal. But it's worth it to file again, give the officer a chance, give USCIS the benefit of the doubt that they just had a training issue. But we will say in this cover, the second filing, that this is our second filing already, our filing, and the client had their own filing. So the client paid 3 application fees, right? Again, it's not just L1, it's also L2. So the client paid easily over $7,000 in application fees to be denied once, to be denied twice, and now it's the 3rd time applying. And that's not even counting all the legal fees and all the extra work to have to go into this case. Filed it the 3rd time. We got a request for evidence. The client is completely disheartened. But again, this 3rd filing, at least the request for evidence challenged certain things about the case that they written in. And we were able to look at it, reason, and provide a response. We filed the request for evidence, and within 3 weeks, the case was approved. We just got it last week. I have the entire case in front of me, and I'm going to walk you through how we got this incredibly difficult L1A case approved. Let's go. My name is Joseph. I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. And the legal problem here today is that as a foreigner trying to come into the United States as an executive to get an L1A visa, it is extremely hard. Because to start a new company, an L1 brand new company, you're investing money, you have a business plan, you're trying to hire workers, but you have to prove that within 1 year, you will have a running enterprise that can sustain a managerial executive position. But based on what? Based on paperwork, based on documents, right? So the client didn't invest that much money into the US. They have a small office. It's an education company, okay? They're doing tutoring. So how much money can they make? How many people can they hire in order to justify this executive level position? It's a hard argument. Again, with 2 denials behind them, this third filing, most likely with the same officer who denied them in the past, looks at this case again. What did you submit now? What makes it new now? Well, the second filing, we argued, we submitted so much, but you didn't respond to any of them, and you just gave a boilerplate saying that it was not enough, and you just denied it. But that's not reasonable. Here's the case law why. Here's the adjudicated field manual. This is what you're supposed to be looking at. We submitted so many things to argue that this client can come in, make America great, make a great company, hire a lot of teachers. How come you didn't address any of these? So I want to make sure the client's information cannot be seen. We got the request for evidence in front of us. The RFE challenged the 1-year requirement. It says, your organization must show that the intended United States operation within 1 year of the approval of this petition will support an executive and managerial position. You provided a proposed nature of the office, the size of the U.S., and organizational chart. You provided a cover letter, letters of support, copy of business plan, proposed entity organizational chart, copy of list of duties and hierarchies, copy of intended cooperation agreements, but it is insufficient. Why? And then they go in depth talking about a whole bunch of stuff. And so your organization may still submit a more detailed original letter from the foreign company explaining what they're going to do, a copy of a feasibility study, a market study, a copy of a proposed line and block organizational chart for the new office, and any other evidence that demonstrate the above analysis. Essentially, they just don't believe that a small U.S. company that's focusing on education is going to sustain an international executive from overseas. No matter what we provide, organizational chart, they don't buy it. So this request for evidence, we submitted 18 documents. I'm going to read them to you. It was a total of 14 pages of attorney brief. We had our business development team, John and Alan, just be buried in this case for 3 weeks to prepare. No, more than that. 3 months to prepare for this request for evidence. Filed it the day before the request for evidence was due, and then got the approval. Just so you know, the client was so disheartened by this third request for evidence after 2 denials, the client just didn't give anything. We've given everything we can possibly give, and other than a few things that we can sign, we can't give any more. So we did our best, responded, prepared a completely dedicated custom brief, just like as we always do. But here's the 18 supporting exhibits that we provided. Updated business plan, updated company organizational chart, table showing the company hierarchy, exactly what USCIS wanted. The secretary's progress report to the owner, the partnership agreements with private education companies, acquisition agreements between different companies, U.S. employment agreements with onboarding personnel, office lease, U.S. bank statements for the startup, business liability insurance, website showing all the services that they're offering, corporate meeting minutes, market research mapping all of the strategies. We provided actually 3 different market research maps where we talk about employment offer letter, we did resume, we did U.S. job posting, we did the workflow, we did clarification of its 1-year hiring plan. These were the 18 documents explained in 14 pages, submitted in total of 150 pages. of documents to respond, and the case was approved. Part of the core argument is that this educational company is hiring and is going to hire a lot of U.S. teachers, helping them make more money so that they can have a better life. U.S. teachers have great benefits if they work for the public, right, public schools, but they don't have a high salary compared to other countries. U.S. gives great pension plans and good benefits, but they have to do overtime, they have to do coaching, they have to do something else during the summer to kind of make up for that wage gap. But American teachers are amazingly good. They're trained. There's so many things, not just because they're smarter per se, but because they know the U.S. education system. And that's what makes America so special. The U.S. education to get to college is so unique. The AP courses, the constantly changing curriculums, the U.S. teachers know that more than anyone else in the world. And so that they are able to provide that resource, that insight, that teaching, especially AP courses. And so this education institution is hiring these teachers to be the tutors, and then they're able to get a high salary to make Americans' teachers better. This foreigner invested money into the U.S. to set up a company to hire teachers to make American students better. If you deny this case, it forfeits this entire plan. And maybe other people will do it, maybe nobody will do it. It hasn't been done, so obviously people are not doing it. But this entrepreneur had this insight that this is a good business plan, but they tried twice and it failed. And this is the third time, after paying thousands and thousands, they finally got the case to be approved. Let me ask you, does this make America great or not? Does this foreigner, is it diluting the American value or not? Is education an American value? Is having a better wage for American teachers an American value? Is making America's education system better and exporting that to the rest of the world an American value? If you answer yes, and no Americans are doing it, and this entrepreneur is going to do it, why stop them? So this case was the third filing, and we got it approved. And so I just want to share that with you guys today. L1A cases are getting increasingly difficult, but it's not impossible. And onward and upward for the next filing and for the family to get a green card. And that's it for today's L1A story. If you guys have any questions, feel free to reach out. See you guys later. Thank you, everyone. Take care. Bye-bye.